Webinar
is now live. And people are joining.
We'll take a few moments for folks to join us and we'll get started shortly.
Okay, it's whatever. I'm got the whole evening here.
will be there.
It's just 8 o'clock. Take one more moment for people to arrive if they're a little tardy. And I hope everyone can overcome whatever technological obstacles they may have encountered. Well, let's get started. Good evening. I'm Bob Goldstein, president of the Rochester, New York chapter of Americans United for Separation of Church and State. I'm delighted to welcome you all to this transcontinentally Zoomed event, hosted by the Rochester, New York chapter, but in active collaboration with and with the assistance of the Houston, Texas chapter, led by Nancy Friedman, who you will be seeing a little bit later. Think about it. Rochester, Houston, Los Angeles, Nashville, and goodness only knows where else, all joined by this invisible electronic thread. What a time we live in. And a special welcome to both members and non-members of Americans United. We hope that those of you who are not yet members will consider joining our fellowship of commitment to and support of the First Amendment. A little more about this later. Tonight, we have a very special guest who we are eagerly waiting to hear. Eddie Tabash from Los Angeles is a constitutional attorney who is widely known as an active and effective defender of the principle of separation of church and state. He's an honors graduate of UCLA and received his law degree from Loyola School of Law in Los Angeles. His long list of organizational participation includes the chairmanship of the board of directors of the Center for Inquiry, and is a long-serving member of the Board of Trustees of Americans United. I could go on for 20 minutes more about all that Eddie has been doing, but I think I need simply say he is the real deal, and he is someone who gives true meaning to the terms citizen and patriot. Just before the 2016 presidential election, Eddie had spoken about the potential for that election to determine the fundamental orientation of the US Supreme Court. And he foretold the danger that shift might mean to church-state separation. Well, here we are in 2021, and what Eddie had warned of has come to pass. The focus of his talk tonight will therefore be on, given a 2/3 religious right majority on the Supreme Court, can we salvage church-state separation at all? Following Eddie's presentation, we'll be happy to have a question and answer period, and you'll be able to do that by the Q&A section, not a chat form, but by Q&A. So Eddie, the Zoom is yours.
Thank you very much for that very kind introduction. I want to thank the Rochester and Houston chapters of Americans United for sponsoring and participating in this presentation. I want to thank Bob Goldstein of the Rochester chapter for initially arranging this event. And I want to thank my colleague on the AU Board of Trustees, Nancy Friedman, and Keith Thompson for bringing in the Houston chapter. And thanks to everybody involved in this high-tech Zoom process, which I don't really understand yet. A number of my colleagues in church-state separation over the years have heard me sound the alarm that the Supreme Court could very likely fall to the religious right if we have the wrong president and a majority in the Senate to confirm that president's court nominees. Well, we did in fact lose the Supreme Court, and this is all because of a guy who couldn't keep his casinos out of bankruptcy. Now, Trump's putting Gorsuch, Kavanaugh, and Barrett on the Supreme Court has created a 6-3 religious right majority. 2/3 of the court are religious right wing, and 1/3 of that 2/3 has been appointed by Trump. Before leaving office, Trump also appointed religious right wing judges to 30% of all judgeships on the courts of appeal in the federal system and 25% of all federal district court judges. We need to understand what we mean for our purposes this evening by separation of church and state. And so I will read from the 1947 Supreme Court case of Everson versus Board of Education. The establishment of religion cause of the First Amendment means at least this: neither a state nor the federal government can set up a church. Neither can pass laws which aid one religion and all religions or prefer one religion over another. Neither can force nor influence a person to go to or remain away from church against their will or force them to profess a belief or disbelief in any religion. No person can be punished for entertaining or professing religious beliefs or disbeliefs, for church attendance or non-attendance. No tax in any amount, large or small, can be levied to support any religious activities or institutions, whatever they may be called, or whatever form they may adopt to teach or practice religion. Then in 1961, in Turcaso versus Watkins, the court reaffirmed this and said that no branch of government can force any person to profess or a belief or disbelief in any religion, and neither can, and this is crucial for our purposes now, no branch of government can constitutionally pass laws or impose requirements which aid all religions as against non-believers. And neither can those religions based on a belief in the existence of God have any preference to those founded on different beliefs. And then one of the most important formulations of this concept was expressed by Justice Souter in the majority opinion in 2005 in McCreary County versus ACLU, striking down the posting of the 10 Commandments in Kentucky elementary school classrooms. And he said, no branch of government, writing for a majority of 5 at the time, can favor religion over irreligion. It is this phrase that is crucial to making sure that believers and non-believers are equal before the law. Now, I have, and I hope you received, 2 handouts which demonstrate remarkably how the framers really intended government to be neutral in matters of religion and all points of view on matters of religion to be treated equally. And that explains the history, which we don't have time to go into now. So for our purposes this evening, what is the purview of cases that trigger separation of church and state? For purposes of determining when a case triggers the question of our trying to keep government from privileging religion and our trying to enforce overall government neutrality in matters of religion, we determine if our side loses, does the side that wins, have they obtained a special legal privilege available only to religious claimants? Or will the winning side have achieved a favoring of religion or religious beliefs over any other types of beliefs on the part of the branch of government in question? In keeping with this approach, we have included within the purview of the AU mission and the issues and cases we take on, situations that threaten LGBTQ rights, jeopardize reproductive freedoms, including access to abortion and contraception. Whenever there are legislative or regulatory efforts to curtail or eliminate these freedoms that wind up in the courts or are winding their way through various legislative and regulatory bodies, if the effort on the part of our opponents are always exposable as being undertaken for religious reasons and for no independent secular grounds. Justice Scalia, in that 2005 Ten Commandments case dissenting, said something very chilling. And this is what frightens those of us who happen to be non-believers, because there are potentially 6 people on the court who agree with this. He said, the principle that government cannot favor religion over irreligion is demonstrably false. That's already a clear statement of second-class citizenship for those who are non-believers. How far can that go? And then Scalia further writes, and he now has 6 people more or less adopting this view, it is entirely clear from our nation's historical practices that the Establishment Clause permits a disregard of polytheists and believers in unconcerned deities, just as it permits the disregard of devout atheists. So that means that Justice Scalia, a pioneer in trying to turn America into a theocracy, believes that the First Amendment does not protect atheists and doesn't even protect anyone who is part of a belief system that's not based on pure monotheism. Now, Justice Clarence Thomas has gone a step further. I don't think yet that there are 4 other justices to give him the majority on this, but it is frightening. Justice Thomas takes the position that the Establishment Clause, which we say, and which the framers created to say everyone must be equal before the law, exists not to protect individual rights, but only exists to prevent the federal government from interfering in state religions. Therefore, unbelievably, Thomas takes the view that the Establishment Clause was put into effect only to make sure the federal government doesn't stop a state from having an official religion if it wants to. I mean, this is really the stuff of nightmares. So as I alluded to earlier, we are caught in a pincer movement between two aspects of weakening government neutrality in matters of religion. One of the dangerous maneuvers is for the court to start upholding religion promoting laws, and the other bookend to this is for the court to start upholding religion privileging laws. A religious promoting law, for instance, would be allowing public schools to have formal prayers and recitations of the Bible, which were respectively deemed unconstitutional in 1962 and 1963. Religious privileging laws are those in which only religious objectors and no one else can avoid complying with otherwise universally applicable laws. An example of this is when we lost the Burwell versus Hobby Lobby case in 2014. What the court said is that even though the Obamacare mandate required every employer to provide insurance coverage for contraception for their employees, only those claiming a religious objection should be able to opt out of doing this. It's very, very frightening to our constitutional system when only people claiming religious objections can avoid by complying with laws that are binding on everyone else. Now, with respect to religion promoting laws, there is no foreseeable limit to what that would mean. If Scalia's view prevails that government can favor religion over irreligion, could the government treat prisoners more leniently if they participate in a religious program? Now, this has been tried and struck down. In October of last year, a federal district court in Virginia ruled that it was unconstitutional for a jail to preserve a certain area only for those who participate in a Christian program. Now, this lawsuit was brought by the Council on American Islamic Relations, and the court mentioned that government cannot favor one religion over another. But how would that court have ruled if the jail provided a special place for believers in any and all religions, but excluded those without any professed religious beliefs? Now, would the new Supreme Court majority uphold a law that would allow only religious nonprofits to be able to endorse candidates for political office, but not give the same rights to secular nonprofits? What kind of dangerous preferentialism would that be? Now, this is what the court did last year in 2020, even before Barrett replaced Ginsburg. It struck down the no aid provision in the Montana Constitution, which prohibited aid to a school controlled by a church, sect, or denomination. It rejected federal employment discrimination claims brought by two elementary school teachers at Catholic schools in Los Angeles. This was a horrendous decision. The ministerial exception allows all religions to hire and fire clergy who promote and proselytize the faith. But here they fired a woman teacher in a non-proselytizing capacity because she had breast cancer. No other employer could get away with that. And yet the Supreme Court ruled that the ministerial exception extends to all employees, and thus religious institutions are not bound by the disability and anti-discrimination laws of our country. The court also held, in face of a very strong dissent by Justice Ginsburg, that the Department of Health and Human Services and the Treasury have the statutory authority to provide exemptions from the regulatory contraceptive requirements of the Patient Protection and Affordable Care Act, Obamacare, for those with religious objections. And then in Roman Catholic Diocese of Brooklyn versus Cuomo, it struck down Governor Cuomo's restrictions on number of people who can gather for worship services on grounds of free exercise of religion. But here again, religious preferentialism, very sharply and on target. In dissent, Justice Breyer pointed out that the rules it established for religious bodies also applied to similar meetings at public lectures, concerts, and theatrical performances, where, as in places of worship, people were more likely to be gathered more closely for long periods of time. So what the court did was to say that even if gatherings are similarly situated with identical risks, government can favor the religious one. The most important pending case is another ominous one, Fulton versus City of Philadelphia, which the court has under submission now. Philadelphia found out that some of its foster care providers would not license same-sex couples to be foster parents, and the city ceased referring children to these agencies, including Catholic Social Services. The Catholic group sued the city, arguing that they had a constitutional free exercise of religion right to refuse to allow same-sex couples to become foster parents because of the church's opposition to same-sex marriage and same-sex living arrangements. The Catholic group is essentially arguing that any religious organization has a special right to be exempt from Philadelphia's otherwise universally applicable law prohibiting the city from funding discriminatory foster care and adoption programs. This is a very egregious instance of demanding an unconstitutional special privileging of religion. A government-funded program should not assist those organizations and individuals involved in placing children in foster care to become involved when taxpayer money is involved, when those organizations would use religious belief systems to reject potential foster parents because they were an LGBTQ couple. I want to point out now what the true purpose of the free exercise clause was. It was not meant as a sword to give the religious special rights. It was meant as a shield to bolster equal rights, and we have no problem with this. The best example of this was in 1993, when the city of Hialeah, Florida, passed a law saying that you could kill an animal for any reason or no reason, but not if the reason were one of a religiously motivated practice of animal sacrifice. This was clearly done to get at a practice of the Santeria Church. And the Supreme Court rightfully found this unconstitutional because here, as the flip side, only the religious were denied rights everybody else has. And so the concept, though, of getting back again to the other side of the coin, only the religious to successfully raise objections to complying with laws that are otherwise applicable to everyone else is fraught with danger. In May of 2019, Trump and Pence had the Department of Human Services issue a regulation that permitted those with religious objections to withhold medical care based on those religious objections. Luckily, federal trial courts struck down this denial of care regulation. And as Americans United pointed out at the time, the language was so broad that it could have allowed a paramedic to refuse to rescue an LGBTQ person from a collapsed building if the paramedic claimed a religious objection to doing so. The whole realm of allowing only the religious to get away with violating anti-discrimination laws would be potentially unlimited. What if a restaurant owner who owns a business that serves the general public claims a sincerely held religious objection to doing business and serving atheists and members of the LGBTQ community? Could that restaurant owner turn away members of those communities from the lunch counter, even though that does business with the general public? What does that remind us of? And so this is where we can see the new court's majorities permitting religion promoting government action and religious privileging action, how it can lead to the erosion of the actual civil rights of non-believers and the erosion of the civil rights of anyone who does not put in a claim for a special privilege that is demonstrably grounded in religion. The court is heading towards a society in which only those who make religious claims or objections have the full scope of rights. There are, of course, a number of cases still pending in the courts, and it's not yet been determined whether various businesses can refuse to provide services for members of the LGBTQ community. However, what would the 6th religious right vote majority do if a lending institution said, we are run by religious people and we don't want to make loans to non-believers or to LGBTQ people? Would the court uphold that as a right of free exercise of religion? As Justice Ginsburg said in her dissent in the Hobby Lobby case, the frightening aspect of this is it appears to be open-ended. Justice Kavanaugh, when he was on the DC Court of Appeal before he got appointed successfully to the Supreme Court, took the position that all you have to do is assert any religious opposition to a law that otherwise applies to everybody else, and you're automatically entitled to exemption. In this, he joins with Justice Alito, Justice Thomas, and as we've seen, the 3 others. Now, under the Affordable Care Act, after you have said, I'm a religious employer, I won't provide coverage for contraception, all the government asks you to do is notify the government so the government can supply the coverage for contraception. But in a 2015 case of Priest versus Life for Life versus United States Department of Health and Human Services, an organization of Catholic priests who oppose both abortion and contraception, said they didn't even want to have to notify the government because it forces them to become a participant in a process whereby the government will ultimately give their employees coverage for contraception. All of us said that's way too remote, but yet the entire Court of Appeals, District of Columbia, sitting en banc, heard this case, and Kavanaugh was one of 3 dissenters out of 12 judges. And he said that if anything violates your religious beliefs in any law, you should be free from compliance. Now, again, to show you the discriminatory disposition of Justice Thomas, and this, I have to say, as a non-believer myself, is really, really scary. In April of 2019, Thomas was at Pepperdine Law School, and he expressed dismay at why atheists would even take oaths because they don't believe in any supreme enforcer of abiding by such oaths. It gets very, very dangerous when even one of the 9 justices on the Supreme Court believe that only those who assert a religious belief can be trusted to not violate solemn oaths in courtroom and other proceedings. One of the things that I need to mention is when we atheists sound the alarm, it's not because we want greater rights than anybody else. We just don't want fewer rights. There has never been an atheist movement to say we want more rights than the religious. We don't just want lesser rights. We don't want government to be able to favor religion over irreligion. And so when numerous Supreme Court justices say that those without religious belief don't have the full protection of the law, the panic is understandable on our part. Now, an example of our wanting the law to apply equally to believers and non-believers was a number of years ago. An atheist public school teacher berated a student for that student's religious beliefs. I insisted at the time to our then executive director, Barry Lynn, that we come down just as hard on this atheist teacher and the school district as we would if a religious school teacher had berated an atheist student. So what does it mean? What does it mean if government at all levels can favor religion over irreligion? Where does that end? How much discrimination could the non-religious face? And most importantly, how much discriminatory conduct in business and other affairs of life could religious objectors be permitted to withhold from people who they say their religion demands they don't do business with? Does this mean that lending institutions, as is said earlier, would be able to refuse to make loans to non-believers and LGBTQ people, or even members of religions that don't worship a monotheistic God? You see, they make these open-ended statements. And again, as Justice Ginsburg pointed out, there's conceivably no limit to the type of second-class citizenship imposed by saying that government and people are free to favor religion over non-religion. Also, women could suffer drastically reduced rights if, as is likely, the new Supreme Court will overturn Roe versus Wade. Now, before I get more into the disastrous consequences of wiping out constitutional acceptance of abortion rights, we have to look at a technical issue. The difference between the religious right and us on many issues, in technical legal terms, comes down to a question of who decides. Who decides? The individual or state and local government? Our view is that such things as a woman's right of choice, such things as people having the right to love those of the same gender, are protected by the Constitution. The religious right says, no, they're not, and therefore there is no limit to what government can do in establishing prohibition. So not only are we talking about legally permissible discrimination, we're talking about the restoration of criminal penalties in the realm of LGBTQ rights and in the realm of abortion rights. In 2003, in Lawrence versus Texas, by a then 6-3 majority, the Supreme Court, in an opinion offered by Justice Kennedy, as he always does, struck down a Texas law and all laws that criminalized private consensual activity by those of the same gender. But that ruling is in jeopardy now. So is the ruling in Obergefell versus Hodges, where again, Justice Kennedy wrote the opinion that found constitutional protection for same-sex marriage. In every LGBTQ opinion of the last 30 years, Justice Kennedy wrote the majority opinion. And so there's a major difference between him and his successor, his former law clerk, Brett Kavanaugh. On October 5th of last year, in the case of Davis versus Ermold, where Kim Davis, a Kentucky licensing clerk, wanted to be able to impose her religion, even though she was acting on behalf of government, to deny marriage licenses to same-sex couples, the Supreme Court denied to hear her case, luckily. But yet, in a dissent, not in a dissent, but in a partial dissent, Justice Alito and Justice Thomas said that the same-sex marriage decision must be overturned. It must be overturned because this woman ideally should have a right not to issue those licenses. I don't think both these justices themselves understood what they were saying. They were saying that even if government should be obligated not to use religion to discriminate against you, government can hire people and put them in the position of implementing government policy, and those people can use their religion to discriminate against you. That is, in a sense, saying government can discriminate against you for prohibited purposes based on who they hire to provide the service. Now, if in fact Roe versus Wade is overturned, there are states that are waiting to treat abortion as murder. A bill introduced into the Arizona legislature in the past few weeks would require that both the woman who sought the abortion and the doctor who performed it be tried for homicide. The Mississippi legislature introduced a bill that would require that the woman seeking the abortion and the performing physician be charged with felony murder. Now, felony murder is when you commit a felony, and as a consequence of your committing the felony, someone dies. So if you rob a bank and the bank guard shoots at you but misses you and hits an innocent bystander, you are on the hook for felony murder because your commission of the felony resulted in the death of the innocent bystander. And they're saying that if you participate or even refer or help anyone procure an abortion, it is a felony whereby you are liable for the death of the fetus, which is no different than a human being, a fully formed, born human being. Now, here is the problem. If, in fact, the court says the question of abortion is entirely up to state legislatures, that means that the court is not imposing limits on the severity with which the states can punish those who participate in the abortion process. So what's frightening here is we have absolutely no guarantee that a court that says abortion is no longer protected rights, but the state can punish it any way they want, except they can't charge it as murder. There's no way we can expect that to happen once it's open-ended. In 2016, we won a case in the Supreme Court where the state of Texas required that even those doctors performing early abortions have hospital admitting privileges. That was struck down. Last year, in June Medical Services versus Russo, the court heard the case again, and we won by a 5-4 split. This was before Barrett replaced Ginsburg. Now, we won because Chief Justice Roberts was our fifth vote, but not because he switched sides. He said that even though he voted to uphold Texas's restrictive laws 2 years ago, he doesn't want the Supreme Court to abandon precedent so soon. But he still agrees with the concept that such restrictions are constitutional. So even if we got Roberts again, with Barrett replacing Ginsburg, we would lose such cases now by 5-4. So the question is, what can we do now? Well, one of the things we have to do is be very cautious in which cases we file and which cases we try to keep the Supreme Court from taking, because the new religious right-wing majority will create bad precedent. We have another problem in that state legislatures are far more likely to favor religion promoting laws. And since state court judges have to face the voters, they're more frightened of ruling against God, as they would see it in many states. We need to start lobbying legislatures, and we also need, and I've been saying this for decades now, for people who support government neutrality in matters of religion, regardless of your personal religious viewpoint, belief or non-belief. We need committed church-state separationists to start running for office, particularly on local school boards and for state legislatures. Because if we can't rely on the courts for now, we're going to have to rely on achieving legislative change or blocking legislation, which we know the new Supreme Court would uphold. It's very, very poignant that Justice O'Connor, before leaving the court in 2005, in her last opinion wrote, "Those who would renegotiate the boundaries between church and state must therefore answer a difficult question. Why would we trade a system that has served us so well for one that has served others so poorly?" The first woman ever to serve on the Supreme Court, a Reagan appointee, was trying to protect church-state separation. And most unusually, she has said that she believes that Justice Alito is dismantling her legacy on that issue. We hope that all of you watching this would help support Americans United for Separation of Church and State. This is the organization that must thrive and be able to continue working in order to preserve that most precious goal, equality of everyone, regardless of their viewpoint on matters of religion. And also, even if we don't live in our lifetimes to see a restoration of church-state separation, keeping the religious right from succeeding is a cause so noble that we need to devote ourselves to it, even if we don't succeed or don't succeed right now. Whatever we do, let us not forfeit the most foundational liberty envisioned by the framers of our Constitution and Bill of Rights, the separation of church and state. Thank you very much for attending. I'll be happy to answer questions.
Wow. Eddie, this is Nancy Friedman, everybody. I said wow because this was a very sobering talk and a very frightening talk. Eddie, I have known since I joined the board of Americans United some time ago, and Eddie has been warning of this ever since I've known him. So it is very sobering to hear that we've come to pass what Eddie's been predicting. We do have some questions I'm going to pose to Eddie. I want to remind you all, if you have any questions, put them in the Q&A. Eddie, first, somebody asks, you just said a moment ago, if we can't rely on the courts for now, we're going to need to rely on legislatures and other local governing bodies. And in fact, you encourage people to run for office. So one of our audience members asked about that. His question is, we're past the point of convincing this Supreme Court that there really is something called the separation of church and state. We could produce a DVD showing the founding fathers saying, we don't want any money going to churches, and the Supreme Court would ignore it. So he asked, is there a legislative solution we could try instead? It could be something like expanding the number of justices that some people had been talking about a month or so ago, or maybe adding explicit protections for LGBTQ and atheists. Couldn't Congress deny or limit standing to free exercise litigants?
This is an excellent question. First of all, on the idea of expanding the number of justices, I bounce back and forth on that so much that, and Nancy, this is the first time that you've ever seen this. I actually don't know where I stand on that. Because if we do it, the next religious right president will add even more. And then the next church-state separationist will add more. And we'll have a court of 51 judges. So I don't know what the solution is. The questioner asked a very profound question. Can Congress limit who can litigate before the Supreme Court? Probably not, because if you have constitutional rights and constitutional issues the Constitution itself grants you the right to have them resolved. And I don't think legislative bodies could cut that off. For instance, in the First Amendment, the right of free speech. Well, I don't think that Congress can say you can no longer bring free speech cases through the federal court system. Now, as far as legislation is concerned, this is where we have a very grave situation with the current court. This is the problem. If in fact legislatures pass pro-church state separation measures, would the opponents be able to have the Supreme Court declare them unconstitutional? So for instance, if a legislature passed a law saying that you cannot for any reason exclude people of certain categories from your business when you do business with everybody for any reason, would the Supreme Court strike down that law and say, no, the plaintiff's right of free exercise of religion allows them to exclude LGBTQ people from the lunch counter? So you see, this, we don't know to what extent legislation designed to require benevolent treatment of everybody would be struck down by a Supreme Court that now says, wait a minute, a religious objection gives you a special get out of jail free card and you don't have to abide by that non-discriminatory law.
One person asks about the Little Sisters case last year. He says the court allowed in that case for religious and moral exemptions concerning the provision of contraceptives. Can you comment on the addition of the moral exemption?
Yes, that was a very clever subterfuge in order to say, just in case there is ever a majority, again, of pro-church state separation justices, we're not just favoring the religious. Anybody with moral objections can opt out. Okay, the problem with that is that saying anybody in the United States who doesn't like a law and claims an exemption based on either a religious or a non-religious moral aversion doesn't have to comply with the law. Now, what's interesting about that is, first of all, practically speaking, I don't know of any employer who is completely non-religious who opposes the provision of insurance coverage for contraception. It's like in 2007, when one of the handouts, I did the amicus brief before the California Supreme Court, and I said the denial of same-sex marriage is a separation of church and state issue. And I said to the court, one of the justices later told me that they found that funny, where I said, you never will find an organization called Atheists for Traditional Marriage. And what I did, which antagonized some people, is I pointed out that all the amicus briefs on the other side were by religious groups. And I singled out the Knights of Columbus because they claimed they were speaking for everybody. So, yeah, I mean, the questioner raises a very important point about the moral conscience, but if you think it through, it is a ruse to say we're not letting just the religious avoid complying. But if you think it through, it makes no sense because it allows anybody for any expressed reason to not comply with any law.
Eddie, you've mentioned during your presentation courts favoring religion, religious beliefs, religion over irreligion, but is that true of any religion or is it just Christianity? For example, could a Protestant deny service to a Catholic or a Muslim?
That's an excellent question. And you see, this is why I worry for my colleagues in the non-believer community. The court even today says government cannot favor one religion over others, but can favor religion collectively over non-believers. Again, the cases, the classic cases I quoted that are still somewhat in force until the new majority takes the knife to it, say government cannot favor religion over irreligion. The Scalia types say, yes, government can. So the problem is that probably one religion would not be able to discriminate against the adherent of another religion, but anyone could discriminate against a non-believer or a person whose lifestyle or conduct offends their religious beliefs. Now, Scalia, in that quote I gave, permits the disregard of all those people, is the very first time that any religious right-wing justice has mentioned excluding from the sphere of protection for religions anyone that's not monotheistic, which would mean Buddhists, Hindus. No one else seems to have commented on that. Certainly, there would be no way of excluding Muslims because they're monotheistic. But I'm wondering whether justices like Kavanaugh and Barrett, Alito, and Thomas, if given the chance, would pick up on Scalia's language of excluding not only atheists, but deists and pantheists, or as he said, people who believe in many deities. See, again, I don't have all the answers because as per Justice Ginsburg's warning, we don't know where the court would close the door that it's opening right now. At what point would the court say, wait a minute, yes, we said you can favor religion, but you can't do that to somebody? You see, this unfortunately will be unfolding in the next few years.
Actually, along those lines, one of our audience members asked this question. It might be partly facetious, but maybe not. She asked, is this to say that I can claim a moral objection to the way this government uses taxpayer money, therefore I don't have to pay income tax?
Theoretically, yes, except the court has already held that tax collection is exempt from this. So, for instance, you're not able, I'll give you an example. There was a case where the Supreme Court struck down the claim of a Jehovah's Witness employer who didn't want to pay in Social Security taxes for his employees, saying he didn't believe in Social Security. And the court said, you have a right to opt out for yourself, but you have no right to impose your religion on your unwillingly on your employees and deprive them because of your personal beliefs of their right to participate in the Social Security system. So if that kind of thing were to hold, you probably wouldn't be exempt from taxation, but you would be able to discriminate in your business practice. And the reason why I say the court's not going to allow people to do that is because what this court particularly wouldn't want is for all of a sudden millions of Quakers to stand up and say, I'm not going to pay taxes because my religious belief does not support defense spending. So I have to have proof that my tax payments, unlike others, will never go to the Pentagon.
One person wanted to be sure she understood you correctly because she's fearful that if she understood you correctly, then it's much worse than she realized. And here's her question. Are you saying that some federal justices would be willing to ignore the 14th Amendment, quote, no state shall make or enforce any law which shall abridge the privileges or immunities, etc., because the issue is religion?
That's a wonderful, wonderful question. And the questioner asks a really profound question because it also harkens back to one of the great foundations, which I didn't have time to mention, and that is that the 14th Amendment incorporated the Bill of Rights to the states in the first place. Before that, it just applied to the federal government. See, the question is this: if the Supreme Court takes the view that government can favor belief over non-belief, then they will say that the 14th Amendment incorporates and applies to the states what they say is now the law. And they say it is now the law that you can use your religious beliefs to discriminate. It is now the law that government can favor believers over non-believers. So the question is this: could non-believers then say we are being denied equal protection of the laws? Could members of the LGBTQ community say, I mean, if you look at the Obergefell decision, the church-state separation aspect was barely even mentioned. It was a question of equal protection of the laws. So if now we have 6 votes to overturn that decision, it would mean that the justices are saying, because we no longer interpret the United States Constitution to protect this right, those who want to claim the right fall outside the Equal Protection Clause, because it's no longer a constitutional right in the first place. But that was really a good question.
This may be an unfair question, but hey, why not? I'll pose it anyway, and that is, so does a person have a religious freedom right to assault the Capitol?
No, you don't have, I mean, you wouldn't have a religious freedom right to do violence against someone, but that's interesting. That actually is a good question, because what the courts are saying, for instance, you can't use your religious beliefs to firebomb the business of a member of the LGBT community, but you can refuse to sell them flowers for their wedding, or you may be able to refuse to seat them in your restaurant. So you can refuse to do business with them, but you can't subject them to a physical assault, them or their property. I mean, we're not going to see any, we're not going to see, I mean, the January 6th assault on the Capitol, I don't think anybody is going to raise a religious freedom right to physically damage the Capitol of the United States. I mean, I don't think that's going to happen.
I'm not sure I share that opinion. I guess my profession was a defense lawyer, and we used to say anybody can claim anything they want when they file a lawsuit. The question is what the judge will do with that lawsuit.
Yeah.
And based on some of what I've seen and some of the footage, people at the Capitol, some of them may assert a religious freedom right.
I think it'll be shot down if they do. I mean,
So.
Yeah, I mean, that would be, because what would happen is those people who claim a religious belief that we have to respect the institutions and physical structure of government could assert a right as taxpayers for a building that equally represents them not to be attacked.
Yeah.
But you're right. I mean, you don't know what people will assert initially.
Yeah. Someone asks, what would be the best, most likely Supreme Court reforms, expansions, et cetera, that we could expect to see? Now, you already talked about your thinking about expansions, but are there any other reforms of the court that you think would be, well, this person says that we could expect to see, or any that you would like to see?
Actually, the way the court must work, there's really nothing we can do. other than hope that Biden gets to make, which doesn't seem likely, inroads in replacing at least 2 of the 6. We see the problem is this: what if there's a change of party majority in the Senate in 2 years? A lot of his judges could be blocked. So a lot of his judicial appointees could be blocked. So you see, what this comes down to is what I've been saying for 4 decades now. Elections for president and US Senate matter. And they matter more for the Supreme Court than on any other issue, because this is the one issue where whoever is president at a given moment in time and whoever has a majority in the Senate in a given moment in time can secure the appointment of literally anyone they want to the Supreme Court. And so when our side loses elections, we are, at least in terms of actually impacting the court, pretty helpless. I don't see, outside of waiting the 6 out and trying to make sure that in the future, when each of them leave the court for whatever reason, that a pro-church state separation president gets to try to replace them. That's all I can really think of. Sometimes when you lose enough elections to your opponents, you're stuck for a good number of years.
Just to clarify, Americans United is a nonpartisan organization.
Oh, yes, absolutely. We take no position on electoral candidates. We don't oppose or support candidates of any party. However, once people are in office, we can criticize their conduct and we can predict what will happen. For instance, if we predicted that an additional vacancy on the Supreme Court would be filled by a religious right-winger, if a different candidate won the November election, that's not an endorsement or opposition, it's a statement of fact. So, nobody can say we're being partisan if we say, oh, and by the way, if Trump had remained in office and Justice Breyer leaves the court, he'd more than likely pick a religious right-winger because his first 3 appointees were. And no one can say we're being partisan if we state the factual reality that Biden is more likely to replace Breyer with a church-state separationist than Trump or Pence would. But of course, I scrupulously have always tried to make sure that we remain nonpartisan. But once people are in office, we obviously can comment on what they do, particularly if they have a track record.
We're coming up on the end of our hour. If anybody wants to stick around, there are a few more questions that Eddie had told us that he would be happy to stay for a little while, but also we promised y'all that it would be an hour. So I want to say a few closing remarks, and then again, if anybody wants to stay, we can try to get to your questions. But first, of course, I want to thank Eddie for this presentation. As I said, it's sobering and it's kind of frightening, but it's realistic. And so we appreciate Eddie taking his time to explain all of this to us. And I also want to thank you, all of you who have joined us tonight. If you are currently a member of Americans United, we appreciate your support. It's going to be important that we maintain a strong organization. If you joined us last month for our program, you got to see the heads of Americans United's legal department, Richard Kapsky, and policy department, Maggie Garrett, as well as the head of the field department, engagement department, Sarah Galuli. We have some great staff, but they need your support. So we appreciate if you are already a member. If your membership has lapsed, please consider rejoining Americans United. its membership starts at only $35 a year. And as Eddie and I can attest, if you didn't have the chance to see our national staff last month, the staff is wonderful and they do a lot of wonderful things. And in fact, a lot of their colleagues refer to them as the best kept secret in Washington, D.C. And finally, if you're a supporter, but you haven't yet had the opportunity to join, please consider joining. If you're a member of the Houston area community, you can join on our chapter's website at auhouston.org. That will make you automatically a member of both the Houston chapter and the national organization. If you are a member of the Rochester community, perhaps Bob can tell us, or there are other, I know people are joining us from all over the country. So you can either reach out to the chapter that's in your area, or you can join through the national organization, au.org. Again, though, if you're a member of the Houston community, we would appreciate your joining through auhouston.org. A couple of more things, questions that were asked. One of them was, will this recording be available to share with others who would be interested in it? Absolutely. We will, the Houston chapter will be publicizing the link. We will promote that to other chapters, or we will let other chapters, including the Rochester chapter, know about the link. So you will be getting that. And if you don't get it, please reach out to whether it's us or the Rochester chapter, somebody. We'll be happy to send that to you. Hopefully, this will also be posted on our AU chapter's Facebook page. We're, for the first time, recording at Facebook under Facebook Live. And so if it comes out, maybe it'll be posted there. But at a minimum, we'll send you the link to the recording. And another question, it's really for you, Eddie, is somebody said there are some incredible quotable quotes in this presentation. Will it be posted where the public can view it?
Will the recording be posted?
Or some of the quotes, the recording will definitely be posted, yeah.
Yeah, I can discuss that with staff and see if I just, what I did was I cobbled together all the relevant Supreme Court cases to show the downward slide we're in. So, I mean, these are all things that AU and all other church-state separation activists know about. But let's see what kind of form it can be put in.
Okay, I'll tell you what, the person who asked this question, why don't you go ahead and contact us? I think you're from the Houston area, so if you want to contact us, email us, and then we can talk about it. If that's something you still want to pursue, and then we can get back with Eddie. Okay, so for those of you who want to jump off, again, thank you very much for joining us. Again, you'll get an email with the link, and we hope that you'll stay tuned, continue to look at the Houston chapter social media. We've got a Facebook page, we have Twitter, and a website. And then, of course, we send out monthly announcements about other programs we're having. So if you would, in fact, next month, we are hoping to present the chair of our national board, Reverend Neil Jones, who is a fabulous speaker. So if you haven't already signed up for our email list, free email list, again, please reach out to us, and we'll be happy to add you to our list. So for those of you who are leaving, thank you very much. Good night. But let's, for those that want to stay on, let's see if we can get Eddie to answer a few more of these questions. Eddie, one person asks, even before Trump, it was clear that the Federalist Society has an outlandish effect on Supreme Court appointments, but, quote, our side, unquote, doesn't even have a list of potential Supreme Court candidates. Should the unelected Federalist Society be investigated for its influence?
If the can I have that again? What if you heard what I just need to repeat it.
Oh, okay.
Yeah.
Let me call it back up again. The person was talking about the Supreme Court justices.
Okay, the Federal Society. Okay. It's a very good question, but this is the only possible answer. Everyone has a right to try to influence the incumbent president. We need to learn from what the religious right did. Now it's the Federalist Society. For more than 20 years, Jerry Falwell and Pat Robertson had the ear of Presidents Reagan, Bush, and Bush when it came to Supreme Court appointments. This is not, I mean, this is something where our side has to develop the contacts. We have to be able to have as much influence on a given administration as the religious right did. I mean, Reagan would listen to Pat Robertson, to Jerry Falwell, to Jesse Helms, then Senator of North Carolina, about these appointments. The religious right had enormous sway over those presidents. And in this sense, the religious right, now acting through the Federalist Society, was able to accomplish the same thing with Trump. You know, so outside of trying to form our own pressure and lobbying groups that are as effective as the religious right has been, I don't know what else we can do. However, I will say, though, that when pro-church state separation presidents are in the White House, they don't seem to need that kind of pressure. I mean, obviously, Trump had to be led by the hand as to who to appoint. I mean, he left to his own devices, I don't think he'd even understand an opinion of the Supreme Court. I mean, if you sat Trump down and said, read this opinion and tell me what it says. Yeah, no, it would be. So
Eddie, I think one difference also with this past administration, I'd like you to comment on, but it could be that this president, when he was running for office, actually released a list of potential judicial nominees or Supreme Court nominees, which I don't know is really a common practice if it's ever been done before. Can you comment on that?
well, I do know this much only, that after Gorsuch, the two top contenders were Kavanaugh and Barrett. When Kennedy retired, it was very close, but it went to Kavanaugh. Now, unexpectedly, when we lost Ginsburg in September, he was able to get Barrett also. But the triumph for the religious right, their greatest triumph, is that both Kavanaugh and Barrett are on the court. You see, remember, I always kept saying they're going to have a 5-vote majority. Even with my infamous pessimism, I didn't expect this. I didn't expect a 6-vote majority. I mean, this is I mean, I'm sure Biden has, I mean, obviously there's nobody that Biden would suggest and nominate for the Supreme Court who wouldn't be good on our issue. I mean, it just doesn't happen. So, but the question is, how does he determine those people? Just like I think Clinton and Obama didn't need us to tell them who to appoint. But I think religious right-wing presidents do, because they don't, I mean, also look at it this way. None of the religious right-wing presidents have been lawyers who are tuned into the legal system. Reagan, Bush, and Trump. So in that sense, I think they're more reliant on ideological pressure groups that are close to them.
Eddie, one person asks if you are familiar with a book, David A. Kaplan's 2018 book, The Most Dangerous Branch, Inside the Supreme Court's Assault on the Constitution. He says he found, this questioner, found it frightening that the author wrote before Kavanaugh was nominated to the Supreme Court, but predicted Kavanaugh's nomination shortly after the book was written. And more frightening is that in 2018, the author predicted that Amy Coney Barrett would be appointed by the Federalist Society if anything happened to Ruth Bader Ginsburg.
I've heard of that book. I haven't read it. Well, obviously, it's not so startling that somebody would predict that if something happened to Justice Ginsburg, that Barrett would replace her if Trump were still president. I mean, that's not remarkable. We all knew that. We all knew that the moment Kavanaugh was chosen and confirmed in October of 18, that if there were another vacancy, Barrett would get it.
And why is that? Why her?
Why her? Because they were the top two choices. Everybody knew that it was, and they were even talking about it. Until the moment Trump announced Kavanaugh, everybody knew it was both of them. So, because Ginsburg died when we really weren't expecting it, and we know she was ill, when Ginsburg died, Trump got to have both of the ones he wanted on the court. Many of us thought it would stop with Kavanaugh and we'd have a 5-4 majority to deal with. We were frightened about Ginsburg's health, but that's why when she died, it felt like the whole world had fallen apart. At first, there was a thought that maybe because the election was so close, given what happened in 2016, when they wouldn't even hold hearings on Obama's nominee, that maybe it wouldn't happen. But the confirmation of Barrett virtually a week before the election, you see, that's what happens when the religious right has a majority in the Senate and holds the presidency. So actually, I know this is not pleasant to hear, but to a large extent, when a given side loses presidential and US Senate campaigns, this kind of thing is to be expected.
Eddie, I'd like to end with one question somebody posed, and I'll be interested in hearing what your response is. The questioner asked, how does the court define religion?
That I have to look up. I think this court defines religion as belief in a supreme being with a certain amount of ritualistic practice or worldviews that attach to it. That I have to look up. I know that there was a definition, I think even in the 19th century. I have to look that one up. I do know this, though, that in California in the 50s, a court of appeal defined religion as not necessarily having any supernatural beliefs, but just having a kind of regularity of practice and ritual that tries to take into account some kind of celebration or acknowledgement of existence. For instance, there are many Unitarians who hold no theistic beliefs. So I don't know what this court would do with that. This is, you see, now would be getting into Scalia's idea that to be a religion, you have to explicitly define yourself as part of a monotheistic belief system. I would be surprised if there's any time a majority of the court said that only those who believe in a single supreme being can call themselves a religion. That is if the Supreme Court said that in the past. Mm-hmm. I have no idea what they would do now.
Well, last night CNN had a program, a special on QAnon. And in some respects, it sounded like, of course, an extremist philosophy. In some respects, it sounded like a cult. But in some respects, it sounded sort of like a religion. Some of the believers believe that the former president is the Messiah. Some people, there was a person on there who was a believer in QAnon until recently, and he was talking to Anderson Cooper and said some of the adherents believe that the former president was even Jesus. They talk about something called a great awakening and a storm. First, I don't know, there's going to be a lot of violence and people are going to be overthrown, and then everything's going to be hunky-dory again. And so the person who was being interviewed said that it brought him a sense of joy. He said the world is so chaotic now that he's felt disconnected. And having something like QAnon to believe in brought him a sense of peace and a sense of joy. And a lot of the people have even made friends. They talk about their families, etc. So I don't know if you're familiar with QAnon enough to comment on this, but you're okay. So I was wondering if, I don't know if there's a supernatural being or not, but like I said, in some respects, do you think the court, does it sound anything like a religion?
I don't know, but here is the closest analogy. I don't think that anybody would question that the Rastafarians have a religion, and their primary spiritual leader or figure or Messiah, I think, was Haile Selassie, the former emperor of Ethiopia, if I'm not mistaken. There was some almost worship of him. So I don't know what the linchpin is. Is it the deification of someone? Is it imputing to in other words, must there be a figure, a definable figure who is deemed by the followers of this contender to be called a religion, who is deemed to be worthy of worship? And then is it worship in the theistic sense, or is it just like idolizing somebody? So, I mean, it's an interesting question. I don't really have the answer to. It was a very interesting question as to whether you can't call yourself a religion if you say that you believe that Trump was God's chosen candidate, but you can call yourself a religion if you say that you believe that Trump himself is imbued with divine properties.
Well, we'll have to see where that takes us. And with that, again, I thank everybody. We are going to call it quits now, but again, thank those who came and who hung around, and thanks, Eddie, for sticking around with us for a little bit extra. Hope to see everybody next month when Neil Jones joins us.
Thank everybody for attending, even though I can't see you.